స్టూల్ లేపి పెట్టు. ఫుల్ చేయదు. అలీ వచ్చాడు సార్, అలీ వచ్చాడు సార్, డిసైడింగ్ అలీ
ఇదిగో ఈ వైర్ ఏంది
అది లైట్కి సార్
సార్
నాకు తెలుసు
ఏపీ
మైకో
అలీ హైదర్ తీసుకోవడం
లింక్ అంటావా
ఇంకా చేద్దాం వా ఏడాడు ప్రాసెస్
అవుతుంది
बता दो
अभी है किधर की
सर अली ने प्रेम्बल
లింక్ షేర్ करना
who enthusiastically waiting hear this lecture by Sri Vaishnav Kumar Garu. All India, you know very well, All India Liars Union, which stands for the cause of people, for law. It should be, constitution is the supreme. It is not any individual or an institution. It is the constitution and its basic structure. Nowadays, you are observing how things are going on. So we thought of a series of lectures we are conducting. All India Liars Union and Law Students Federation of India. You are among you law students, union leaders are here. They are very actively associated with to see that constitutional spirit is maintained. You are all sincere students, seniors, juniors, and some are advocates. You are all here. I sincerely feel that to uphold the constitutional spirit, to see the rule of law is maintained. Nobody is above the law. In that way, all of you, all of us are here to hear the lecture of Sri G. Vaishnav Kumar Garu. I welcome all of you to this lecture, today's lecture, and All India Liars Union and also LSFI will continue to conduct several programs. I request all of you to attend the future programs also. So now I request Mr. Ali Haider, the convener of LSFI, Law Students Federation of India. He will preside over this program, today's lecture, Ali Haider. And then I request today's our lecture of faculty, Professor G. Vaishnav Kumar Garu, please come on to the dais, sir. Dr. G. Vaishnav Kumar Garu. So we welcome you, sir, on behalf of All India Liars Union and also Law Students Federation of India. Mr. K. Pathsarthi, General Secretary of All India Liars Union, Telangana State Committee, who is behind this program and all the time takes lead in conducting programs. He is here, and I request Pathsarthi also, Sri K. Pathsarthi, to come on to the dais. So Mr. Chandrakant, I request to come on to the dais. He is very active and organizer in the program, and then Mr. D. Praveen, President of All India Liars Union, Hyderabad Committee, is here. So I request D. Praveen also to come on to the dais. And not the least but not the last, but Mr. Kranti Kumar, the co-convener of LSFI, I request him to come on to the dais. So now before the President Minister Ali Haider to proceed the proceedings, I request Mr. Chandrakant to read out the preamble of the Constitution. Then Mr. Ali Haider will conduct the proceedings. Thank you, one and all. Good afternoon, everyone. Welcome to the session. And I request everyone to stand a few minutes at your places. Let's read out the preamble. We, the people of India, having solemnly resolved to constitute India into a sovereign socialist, secular democratic republic, and to secure all its citizens justice, social, economic, and political liberty of thought,
expression, belief, faith and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you.
इधर ये तरफ
Good afternoon, everyone. I welcome you all to this enlightening section on Constitution, the basic document of Constitution. I am Ali Haider, State Convener for Law Student Federation, AILU Law Students Wing. I welcome you all once again. Today's lecture will be focusing on basic document of Constitution by none other than the genius and the whatever I will say it will be less. The Vaishnav sir is sitting with us and it is my privilege again. I am sitting with him, I am sharing the dais, and the K. Parthasarathi sir, whose efforts are restless towards students and this legal fraternity in organizing the programs like such. There are many programs which we organized in previous batches. Many students are new, belonging to first years, they are not aware of it. AILU, All India Lawyers Union, is always dedicated to upholding Constitution of India, the basic principles, socialism, secular. The AILU is established by notable judges when it was needed in this nation. Now today we will back to the topic, the basic doctrine of the Constitution by Vaishnav sir. Before giving mic to Vaishnav sir, I will request K. Parthasarathi sir, AILU Telangana State Secretary, to say few words about the today's topic.
Good afternoon to all. The All India Lawyers Union has been organizing such a lectures regularly. On this constitutional day, it is on November 26th, as for the convenience sake, because we have a number of programs on that particular day, on next Saturday as well. So we thought of organizing a seminar earlier. So that is one aspect. The other aspect is the All India Lawyers Union was formed in 1983 with the concept and with the experiences of the Indian situation. Because you all know, I think very few people know about the emergency that was declared in 1975. Anybody knows about that? Certain people. But nowadays, now the students are not familiar with that. That is the aspect. When the emergency was declared, the fundamental rights was taken away with the government. At that time, the advocates have protested, but nothing has happened. And in 1977, February or March I think so, the emergency was lifted. After that, elections took place. The government has changed. After the elections, the retired judges of the Supreme Court, A.G. Desai, Krishnaya, B.R. Krishnaya and others, sat together with the senior advocates of the Supreme Court, discussed, in future such a situation does not arise. We have to safeguard the Constitution. We have to safeguard the fundamental rights. We have to safeguard the independence of the judiciary. All these aspects they have discussed. and formed an organization called All India Lawyers Union. In that way, All India Lawyers Union was formed, and we are carrying forward that. Our aim, task, motto, everything, whatever it may be, save constitution, save democracy, save rule of law, save independence of judiciary, all these aspects we are fighting. All these days after 83 was formed, it has been continuously functioning throughout the country, in various parts of the country. Most of the states we have, and we have a smaller states where we don't have. Now we are started organizing that in that states also. So in that aspect, but one aspect we have to remember, before independence, what was our situation? When the Britishers were ruling for 200 years, what was the situation of the human beings of India? What happened? They were not treated as human beings. That was the situation. After that, we fought for the independence. We achieved the independence. After that, we have written a constitution that was written by Dr. Baba Ambedkar. Baba Sahib Ambedkar. He did not write as an individual. He studied various countries of the constitution in the world and prepared an Indian constitution. In that way we are now the present. So this constitution has to be safeguarded at any point. Recently I have read, I don't know, anybody has read that article of Ambedkar did not write the constitution, or he has not done that. It is B.C. Rao, B.N. Rao. Who is B.N. Rao? He was a civil servant in the Britishers administration. And he has written, no, that is totally wrong. That they want to bring some idea in focusing that Ambedkar has not. It is the Ambedkar who has written the constitution. No doubt, there may be a team of members who were part and parcel of the constitution. That is the situation. In this background, in this juncture, it is better you should learn, read, and teach the others, because many in India today also many people do not write and read. But then we have to teach the constitution, what the constitution is, what the fundamental rights are, what are the rights of the woman, rights of the workers, rights of the child. All these is we have to teach as a lawyers, law students and lawyers, we have to teach them. And that is the constitution. With this, we thought of holding such a seminar or lecture by Professor Vaishnav Kumar Garu. I came to know, I did not hear previously, I came to know that he is a eminent lawyer, eminent professor in teaching the constitution. So, the constitution and the as we have a basic structure of the constitution, this constitution cannot be changed. If at all they want to change, they have to change the basic structure of the constitution. That was in the judgment. So that we professor will give a lecture on it. Thank you very much.
Thank you, sir, for giving the overview of All India Lawyers Union and today's program. Dear friends, what I believe is the machinery of the nation stands on the Indhan of Constitution. Whatever we are doing, whatever we are seeing, this is because of the Constitution basically. Right to breath, right to sleep is also our fundamental right. That is given by the Supreme Court of India. It is not like you cannot sleep without the right. But when it is established right, you can fight for it on the account of infringement. If you are, the basic structure which we are going to discuss today by Vaishnav sir, the basic structure on which the constitution is standing. Our constitution is considered as the living document. There are very few documents which can be considered as a living. Living means first question in your mind will come whether it is breathing. Yes, every day a new amendment is coming. Every day new interpretation is coming. Every day you are seeing a new change in constitution. Constitutional the laws which are there, which are enacted, these all are backed up by the Constitution of India. Whether it is a Motor Vehicle Act, whether it is a Negotiable Instrument Act, any act you take, it is backed up by the Constitution of India basically. Constitution of India, the basic document on which we all are relying. The harmony between us, everything depends on the Constitution. The Constitution of India, while preparing Constitution, there were many arguments took place. Like right to property was there. Afterwards, it was removed. It was basically a fundamental right to hold the property, and it was removed by the amendment. Many things in 1942, in the 72nd Amendment by Indira Gandhi, it was considered as a mini constitution, but the basic structure is always constant. It is like heart of the constitution. The today which Vaishnav sir is going to discuss the basic doctrine of the constitution. Constitution is based on the basic doctrine. There is always a principle, ideology on which a document survives. Whether it is a religious text, whether it is an ideological book, everything survives on one ideology. If you take Gita, it will survive on some ideology. If you take Quran, it survives on some ideology. Same like the constitution survives on the ideology of socialism and secularism. From last decades, All India Lawyers Union is surviving, struggling hard to safeguard the basic principles of the constitution. Right to privacy, which was established in 2017 by Kutuswamy vs. Union of India. And one of the council, P. Surendranath, is the president of All India Lawyers Union National Committee. AILU is always standing to safeguard the constitution. Today's lecture will be focusing on that aspect of the basic doctrine, and you all are here in a huge strength. It's our privilege to hold a session like this in future even. The All India Lawyers Union and the Student Wing of All India Lawyers Union is always standing with the students' rights and everything. And I want to remind you, my dear juniors who are in the first year now, who are new to law, you may be doing internships, and internship became a very integral part of our curriculum academics. That is the gift given by the All India Lawyers Union. It was the outcome of first Students' Convention in 2017, which held at Marwadi Shiksha Samiti College. So we made this compulsory internship part of our curriculum, academics. So we are struggling hard to bring changes in the academics curriculum, which will make us a prominent practical advocate when we pass out. Because the law subjects are mostly focused on theories. We want to give the practical experience to the advocates, not just internships. We are focusing to introduce many things like jail visits, which is already practiced in national law universities. If you visit the jails, you will understand the mechanism, how it is working. Internships with the commissions like human rights commissions and everywhere, you will understand the working of national constitutional bodies. So we are planning and we are working on it. Very soon you will see the results. Newly enrolled advocates who are sitting. We are planning to hold All India bar exam free classes from this Monday hopefully. We are finalizing it. Whatever the belief of K. Parthasarthi sir here in particularly Telangana is that education cannot be sold. The legal education is to be shared, and you are the spark. You in future you will stand with us. You will stand to safeguard the constitution. You will stand to safeguard the basic principles of the constitution. Now it's time. I would like to request our eminent guest today, Vaishnav sir, to take over the charge of the mic. I have taken so much time being talkative. And I request all the dignitaries of the dais to come down. We can see and learn. Thank you.
ये स्टैंडिंग में हो रही वीडियो, इट्स नॉट फॉर व्यूअर्स। वो उसको बैक करके नई वीडियो स्टार्ट करो। दिस इज इन द स्टैंडिंग पोजीशन, ऐसा स्ट्रेट में। हाँ, तो उसको कैंसिल करके नया स्टार्ट कर दो। ऐसा हाँ, स्ट्रेट कर दो, नहीं तो बेस्ट, दिस विल बी गुड। तो पूरा क्रॉस में गलत हो जाए।
Good afternoon, one and all. Respected Partha Saradi Garu, Ramchandra Reddy sir, Ali Haidar sir, and proactive member Anil Kumar sir, and our hyperactive hero Mr. Chandrakant, and other office bearers of AILU and LSFI, dignitaries, and also my beloved audience. First of all, I thank you for giving me an opportunity and organizing this wonderful lecture on the topic Doctrine of Basic Structure of Indian Constitution. These days we find that there are many forums which are organizing lectures on various topics, but there are very few forums which organize the lectures on the topics related to Constitution. Why? Because since our sir has said, either sir, that Constitution is a living document, but the thing is, when it comes to the academic circles, that subject has become more of on ventilator basis. So it is on the verge of extinction, but don't worry, it won't be extinct. So keeping that view in mind, today's topic of discussion, that is doctrine of basic structure, is one of the most fundamental topic of the Constitution or area of the topic, with which you can connect almost each and every branch of law. Since our Constitution itself happens to be the grand norm of Indian democracy, grand norm, the ultimate norms from which all the laws, authorities in our democratic republic flow from. So this doctrine of basic structure is somewhat which is hidden in all each and every provision of the Constitution of India. It is not something which was invented by the judiciary, it was already inherently there, and it was only expounded by the judiciary in its judgments. So I would like to start my today's lecture by quoting specific lines from Dr. B.R. Ambedkar, who has stated that Constitution is not a mere lawyer's document. It is a vehicle of life, and its spirit is always the spirit of the age. So here in this particular quotation, he has highlighted the liveliness of the Constitution. Constitution is not some old, dusty old book which has come from the heaven, or which is there made by some old men in somewhere around 70 years back. It is a living document. The moment we wake from our night's sleep, we start with the only law, that is the Constitution. Why? Because even sleeping, that is right to sleep, is a constitutional right. So constitutional law or Constitution is the inherent part of a person's life, a citizen's life more particularly. So with this particular background, we will start with the Constitution and its doctrine of basic structure. And first and foremost question which I want to pose to the audience is, can a constitution that gives power to amend itself also give power to destroy itself? Does the constitution have something called as self-destruct button? That is the question. Why? Because technically, if I say that you can change me, you may end up changing the entire portion of me, the entire existence of me. So, against this particular backdrop, the doctrine of basic structure has evolved. This question which we have seen. So, in this lecture, first we will see what is this doctrine of basic structure. We will see why it has evolved. Then we will analyze the judicial odyssey or journey from Shankari Prasad to Keshavananda Bharati and beyond. Then we will look into the essential components which constitute the basic structure of Indian Constitution. Then consolidation and expansion of this particular doctrine, and finally we will conclude with the critics and the defenses in favor of the doctrine of basic structure. Now simply put, the precise definition of basic structure doctrine is nowhere found in the Constitution itself. Why? Because even though the basic structure exists in the Constitution, it was only expounded through judicial precedents. It was only the judiciary which has come to state that this constitutes the basic structure of Indian Constitution. So, what the judiciary has said, it was not even in the case of Keshavananda Bharati where they clearly defined. It was in the case of I.R. Coelho versus State of Tamil Nadu, 2007, where the Indian judiciary, that is the Honorable Supreme Court, has stated that the doctrine of basic structure contemplates that there are certain parts or aspects to the Constitution, including Article 15, 14, 21 and 19, which constitute the core of the Indian Constitution, which if allowed to be abrogated would completely change the nature of the Constitution. For a layman, it is nothing but a definition which is given by the judiciary, highly trained legal intellectuals, full of legal jargon which no one understands. But to make a common person understand about the basic structure, that is where the actual difficulty lies. If you are any other simple graduate, etc., if I say about the basic structure doctrine, you might not even hear about that particular word. Just prior to your LLB, did you ever come across this word, basic structure? No. Might be there in some kind of legal debates or some debates pertaining to the amendments. Very sketchy details will be there, and usually you know how the TV debates are. People sitting, claiming to be intellectuals, and it starts with a very good question, and slowly you will find that the entire debate goes into some other direction. You did that thing, I did this thing. So instead of discussing what actually basic structure is, it is hidden. That is the reason no one can see. But it can be felt. It is just like the breathing air of the Constitution. Until and unless you know about that particular breathing air, you don't know where it exists or how it exists, what is its form. So basically when we proceed further, then to make the basic structure of basic structure doctrine understandable to a layman, you should go to a particular picture which you should bear in mind. What do you see or what do you understand by this picture? Demolition. The entire demolition of a building, right? See, you might be seeing that the foundational pillars are being destroyed. What is the end result? The entire superstructure collapses. So doctrine of basic structure says that our constitution is like a building, which is basing its entire strength, which is founded on these pillars, each pillar being one of the essential attributes of the Constitution. Let it be supremacy of law, independence of judiciary, all these constitute one of the pillars of that particular superstructure called as Constitution. The moment, even if you disturb a single pillar, the stability of the entire Constitution is questionable. It will end. Forget about destroying 10 pillars. You destroy only one, that is enough. You destroy only one pillar, that is enough. But what are those pillars? It is nowhere laid down. It is the result of the evolution from the judiciary. From time to time, they kept on adding certain things, saying that this is the basic feature, this is the basic feature, this is the basic feature. And it is still evolving as on date. So what the judiciary meant to say is, the entire constitution is based upon certain foundational pillars. Certain foundational pillars which have been evolved from something called as constitutional ethos, constitutional ethics, the long drawn principles from our Indian culture, the principles from the Western ideologies, the principles or the ideology behind the national freedom struggle. All these constitute the basic pillars of our Indian constitution. You attack any one of them, the end result is the collapse of entire constitution. So, unlike other countries, you have certain European countries where they are very liberal with the constitution, in fact. So they keep on changing the constitution from time to time. Not amending, let me tell you. They'll repeal the entire constitution and they'll bring a new one. But that is possible in a democracy which is uniform in nature. Democracy, a democratic country where you have common language, common religion, common culture and all. In that particular thing you can do. But when it comes to the constitution like Indian constitution, then the equation is totally different. Ours is a geographically diverse country with cultures changing from time to time, from place to place. 50 kilometers the culture changes, the language changes, the style of wearing the dress even changes, and after 4 or 500 kilometers everything will change, including the state boundaries. So this is the nature of our Indian polity. This is the nature of our Indian polity, or this is the diverse nature of our country. So to ensure that there is a rule of law being followed by all, acceptable by all, you should have a constitution, very strong constitution. A very strong constitution which is based upon very strong foundational principles. When this foundation is strong, obviously it is the infrastructure which will be very strong. If you destroy any one element of that particular constitution, then the entire structure collapses. So now, simply put, we can say that the basic structure holds that certain fundamental features of constitution, such as the supremacy, rule of law, independence of judiciary, they cannot be amended or abrogated by the parliament. Amended means changing to the extent of changing the very fundamental nature itself. So if you want to introduce any kind of change, you either add it, you try to modify it, but you will not go to the extent of changing the actually existing substance. That is what it says. Or abrogation. Abrogation means completely taking it away. Completely taking it away. Or in other words, you can say repeal. Repeal is the word which is used with any ordinary legislation, but when it comes to the constitution, they use the expression abrogation, which is more formal in nature, which indicates more formal process. So, here we will see what is actually the doctrine of basic structure. This doctrine is basically a judicially evolved limitation on the power of Parliament to amend the constitution. Or in other words, you can say it is acting as a limit on the parliamentary sovereignty. Now here we come across something called as parliamentary sovereignty. Yes, can anyone tell me what is parliamentary sovereignty?
They can make the rules as they wish.
Yes, parliamentary sovereignty means the parliament is the most supreme authority, even beyond the constitution itself. So they say about the English constitution. English constitution does not exist in the form of a single book, but it exists in the form of multiple laws scattered here and there. They say that the parliament, the British parliament or parliament of UK more particularly, is the most powerful parliament in the world. It can do anything except turn man into woman and woman into man. That is what the actual quotation about the British parliamentary supremacy is concerned. So here the parliament is supreme. Parliament dictates who is going to be the king. Do you know that? It is the parliament determines who is going to be the monarch. It determines who will succeed after the death of the monarch. It determines how much they can spend. It determines what kind of titles they can have. It also determines where they can go. So in such kind of country, you cannot say that the monarchy is independent. No, even the parliament is the most powerful one. So this parliamentary sovereignty, that is the power of parliament to change anything, do anything under the sky, has to be limited by something. You know, there is something called as the doctrine of checks and balances. A doctrine of checks and balances says that three organs of government, executive, legislature and judiciary, two branches will control the third one. They will not exceed their limits, but at the same time, the other two will ensure that this particular branch will not exceed their limits. There is some sort of inherent control, boundaries laid. Why? Because if you don't have any kind of limitations, then there is every threat that all these three branches of the state or the government may become independent. They will not listen to each other. Just imagine if judiciary doesn't have any control over the legislature, that is the parliament, what will be the situation? Parliament will do everything. It will go to the extent of even destroying the judiciary. Or if the judiciary is not placed under the control of parliament, yes, it is placed under the control of parliament indirectly. Some sort of independence is given to them compared to the executive. Executive is nothing. Executive is the extension of the legislature, that's it. CM is the part of legislature, at the same time he is the part of executive. Same is the case with PM and Council of Ministers. So, the theory of checks and balances, basing upon that particular theory, you wanted some sort of limitation on the power of the parliament. So that to ensure that the parliament doesn't go after the constitution. So here they say that the parliament, this doctrine says that the parliament can amend any part of constitution. Since it is the parliament, power to amend constitution does not vest with any kind of state legislature. That is the thing, basic thing which we already know. State governments cannot bring any kind of constitutional amendments. But it is the union government which is empowered to do so. Union government sitting in the parliament. So it is the union parliament which has got enough power to go after the constitution. But it says that you cannot alter, destroy or abrogate the constitution's identity or core features. So you can amend the constitution. It says you can amend whatever you want, but you will not touch upon or you will not alter, destroy or abrogate the core fundamental pillars of the constitution. So in other words, you can say that you can carry out any kind of interior designing in the building, but you are not supposed to touch the pillar. You do, you destroy the wall, you remove the wall, you erect the partitions, anything you can do, but don't touch the pillars. Why? Because once you touch, the entire democracy will be threatened. The end result will be the death sentence for the democracy. That is what which happens. So someone has to stop this unrestricted or unfettered power of the parliament. So that is where our judiciary steps in. So this doctrine, how it has evolved. Before going into the aspects or other aspects of the doctrine of basic structure, first we should look into the crucial aspect of its evolution. All of us are law students or the lawyers. We know that our Indian constitution, when it was framed, they had a dilemma as to what kind of model of government we should follow. Some suggested that we should go for presidential form. Presidential form of government will not be that much democratically relevant for India. Why? Because here you have numerous category of people. You require wider representation. And at the same time, they went for the model of governance which was already there. That is, directly they have borrowed the British system, also known as the Westminster form of government. named after the British Parliament, which was situated at Westminster. So, Westminster form of government they wanted to introduce in our Indian Constitution. But there is a fundamental flaw with the Westminster model. That is the parliamentary form of government as it exists in UK. I told you, parliamentary sovereignty. And when it comes to the parliamentary sovereignty, UK is a constitutional monarchy only for namesake. It is a constitutional monarchy only namesake. It exists in the namesake. Why? Because here the parliament decides who is going to sit over that chair. And I told you, it dictates almost the entire life of the royalty. They even go to the extent of saying or dictating the king or the queen when to speak and when not to speak. So to that extent they exert the control. But if you go into the history, this kind of control did not arrive that easily. So what happens is, in historical background you will find that in UK, it was the reign of one English monarch called as Charles the First. Charles the First. So someone had told that you are also the head of the Church of England. So you are the king. Why? Because not the parliament has chosen. It is the God which has willed that you should be the king. So slowly he went to the extent of exceeding his limits, and he went on to disobey his own parliament. Disobey his own parliament. He stated that I derive my status from the divine, that is the God. Where is the question of having any kind of parliament authorizing me to rule? No. So what he has done, he went to that particular extent. And things got so bad that finally the king had to wage war with the parliament. Have you ever come across such kind of situation where parliament headed by the prime minister is waging war against the king and his personal army? That was the situation. But nevertheless, the English army is under the exclusive control of the parliament. They arrested the king, and now the actual thing starts. This king who was arrested, he was brought before the parliament. He was tried. The entire trial happened in front of parliament. Just imagine, king sitting in front of the parliament and parliament is prosecuting the king. For which offence? For committing high treason. You know what is the Telugu word for treason? Rajadroham. Ever chesindu? Raju chesindu. It is not about the things which he has done, but he has violated the entire constitutional structure. You know what is the end result? The king was found guilty and he was executed by the parliament. Now that was the final chapter which has sealed the fate of English parliament. English parliament from then on, it was known as the super parliament. It can do anything except from changing man to woman and woman to man. This is the area from where this quotation came. So where the parliament has power to even dictate the king, the constitutional head of the state, we cannot afford to have such kind of power. Why? Because with great difficulty we obtained freedom. With the sacrifices of millions of people, we got it at a very painful cost. Even getting the freedom, after getting the freedom also, the things were not easy for us. The country got divided. Then you had massacres from both the sides, atrocities on people. So when such kind of situation was there, Indian society, deeply divided society, should we concentrate on making the lives of the people better, or should we speak about the constitution or what kind of power we get or who gets the power? That was the situation. During that particular time, they went through the ideals of various nations and the amendment procedures and all. Thanks to Dr. Ambedkar, who has framed a very robust constitution which can withstand the present day, pressures. And if you had any chance of going through the Constituent Assembly debates, you will know each and every provision of constitution, clause of constitution, draft constitution was torn into bits, analyzed into bits by many members. Each and every member. Why? Because all of them hail from legal background. That is one of the reasons they say that the Indian constitution had become bulky. Why? Because it was drafted by all lawyers. And you know how excellent drafting skills we possess. Simple sentence we can drag into an entire paragraph, making it more and more detailed, more and more detailed. That is the reason our constitution is so bulky. Compare it with constitution of US, which is a pocket constitution, which is a very small, very concise one. So here what they have done is, in the constitution itself, since it speaks about a living document, constitution can never be a dead document. A dead law is no law at all. Dead law should make way for the new law. Why? Because the generation changed. The constitutional ethos changed. Just imagine, recently, right to sleep and right to internet was found to be the part of Article 21. Just imagine whether such kind of rights could have been brought in 1947 or 46. No. Evolution of these particular rights happen from time to time. Why? Because the society is always changing. 6 months it changes. In a decade, lot many things change. So to cope up with this particular change, the constitutional makers introduced the amendment power under Article 368, which empowers the Parliament to amend the Constitution. Now, here you should see that amending the Constitution doesn't mean that you bend and amend the Constitution. So there was this Fali Nariman, his famous quotation about Indira Gandhi when they asked, they are bringing 42nd Amendment, these kind of changes are there. Then he told that Indira is capable of mending, bending and amending the Constitution. So amending doesn't mean mending. You know what is mending? Repair. Wherever it is silent, you try to introduce certain things. Then bending to suit your own needs. And whenever you are bending the Constitution, it speaks about the mischief of the Parliament. Bending, bending and amending. Amending to such a nature that you fail to recognize what was the actual Constitution. So you cannot go to that particular power. But the thing is, the peculiarity about Article 368 is it does not say what actually is amending power. If you see the text of 368 will tell about the process. What is the process for amendment? Simple majority, special majority along with ratification by the states. That's it. It doesn't say what is actual amending power. And at the same time, it also doesn't explicitly speak about any limitation on the power of the Constitution. It does not say that here the power ends, here it should begin. No, it is totally silent. It only says that you can amend the Constitution, certain provisions under this process, this procedure. That's it. It doesn't limit the power of the Parliament per se. So what has happened is, this had led to something called as fundamental constitutional tension. A dilemma comes in the light of Article 368, that is, could Parliament with a special majority change even the very soul of the Constitution? Now that is the question. Now, I told you that Parliament can change. Article 368 speaks about the provisions, simple majority, special majority and along with the ratification. So theoretically you can say that a Parliament which is consisting of a single party majority, absolute majority, or you can say brute majority, in the initial stages of our Indian government you can see single party was there having brutal majority, somewhere around more than 300, 350, nearing 400 almost. When such kind of majority is there, brute majority is there, does it entitle the Parliament to even change the basic structure? That was the question. Here we are speaking about a time where no judicial pronouncement was there with regard to the basic structure. Our Indian democracy was still in its infancy, still in its childhood stage. the constitution makers did not contemplate this situation. They thought that everyone will do their task in a pious manner, unbiased manner, working for the country. Those are the people who worked for half salary. They could have taken whatever salary they want, but they did not do so. Why? Because the country cannot afford. Now the situation is quite contrary. No matter which government comes into the power, the first law which they will pass is increasing their salary. That is for certain. And it will be passed with overwhelming majority. Everyone saying yes. Everyone saying yes, unequivocally. The moment it is placed on the floor of the house, the next moment they will say, conduct the voting and pass. But other things cannot be done in that manner. There should be some sort of restriction on the power of the parliament. So this doctrine had evolved as a judicial response to prevent the misuse of amending power of the constitution and to protect the identity. Now when we are speaking about the amending power of the constitution, we will see that one of the strongest constitution in the world. Any idea? Which one? There is no title or given by someone, but the thing is, generally they consider the Constitution of United States of America as the strongest one. But at the same time, it is also the shortest one. Made in the year 1787. From 1787 to 2025. Do you know how many amendments are there? Just 25. And our Indian Constitution, which years? It is not actually 1950s, it is 1949. On this 26th day of November 1949, that is the ending lines of preamble. So from 1949 till 2025, how many? 108 now. Now 108 amendments. Now, does it indicate that our Indian Constitution is a weak constitution? Why? Yes, that is absolutely correct. Within this short span of time, when you have 108 amendments, it shows that our Indian Constitution is much more dynamic than the constitutions like US. Ours is the evolving one, fastest evolving one, suiting to the needs, on an average of 2 or 3 amendments per year. But just because so many amendments are there and our constitution is lively, will it empower the parliament to even touch the actual fundamental nature? See, when I studied about basic structure doctrine, our professor, Dr. Jay Kumar, so he gave one good example. I gave you the example of building. So he gave the example of a woman, stating that basic structure theory says that you can apply whatever makeup you can apply on the face. But you cannot go for plastic surgery. You apply whatever makeup you want, whether it is morning makeup, evening, night, whatever it may be, party look or official look, but you cannot touch the fundamental of the face. You cannot deface. You cannot go for plastic surgery. That is what he used to say. So whatever changes you require in accordance with the needs of the age, you have to definitely incorporate. Why? Because if you don't incorporate the change, the constitution or for that matter any other law becomes obsolete. It becomes obsolete. You cannot use it. It becomes redundant. Just like our old IPC, 1860. Punishments for killing one animal, 10 rupees. Now will you get any animal for 10 rupees in the present day? You will not even get a pair of goldfish. So, it did not evolve that much, but now that is the situation. Constitution cannot remain so. Other laws, yes, they can. But when it comes to the constitution which speaks about and which decides the lives of nearly 130 crore people, it should be dynamic in nature. But changing it doesn't mean you take away its original nature, original flavor, original structure. That is what this doctrine says. That is, it is a doctrine which has been evolved by judiciary. It is the judicial innovation, you can say, judicial activism, judicial innovation, which has happened in our country. And you will be glad to know that there are some countries which started recognizing this doctrine. There are certain countries, recognizing doesn't mean they are applying. They came across certain areas where they started discussing about this basic structure. Some countries said, like Singapore and all, they said that yes, there is a basic structure doctrine in India, but that is fundamentally different from what we follow at Singapore. Yes, dissent and doesn't mean that everyone recognizes. And there is one particular country which recognizes the basic structure doctrine. Ironically, that country suffers from constitutional collapse every now and then. Our good old neighbor. The Supreme Court of Pakistan recognized this doctrine of basic structure, and also the Supreme Court of Malaysia. It has become some sort of guideline for the newly evolving democracies where you have judicial activism and where the governments are trying to change the constitution itself. And it is a very good innovation which is being borrowed. It is not as if that our own Indian judiciary sits and borrows something which has been said in US Supreme Court or Privy Council and all. Now we are in a particular position where our doctrines are being borrowed and discussed in the foreign jurisdictions, which is a very good development. Remember that the constitution is a living organism. It can grow and change. But if you remove its heart or spine, it is bound to collapse. It will die. So, to incorporate the changes needed for the changing societal norms, constitutional ethos and all, you can change the constitution. But that should not go to the extent of destroying the very essence of the constitution. Should not go to the extent of destroying the very essence of the constitution. So it should, you can add more melodies to the original tune. That is what people do, remix. But you will not go to the extent of destroying the original tune itself. That is what the judiciary meant to say. So now, since we have seen that the judiciary has played an important and crucial role in making this particular doctrine or evolving this particular doctrine, we will see how it has started. See, the greatest journey will start from a single step. So that single step by the judiciary was taken in the case of Shankari Prasad. So this entire basic structure doctrine or discussion about the basic structure doctrine is incomplete until and unless you take into consideration the journey from the Shankari Prasad's case to Keshavananda and beyond. Now, even before the Shankari Prasad's case, there was one particular situation. It is not about actually the constitutional amendment, it was about something else. You might have come across a case called as A.K. Gopalan's case. Legality of preventive detention laws. That was challenged. In which year? Any idea? 1950 itself. It got reported in the year 1951. So, barely 1 year after the enforcement of the Indian Constitution, this kind of situation had arisen. Now, in A.K. Gopalan's case, you know what has happened. A prominent leader, he was not allowed to participate, he was restricted, he was detained. Now, the beauty of preventive detention law is, you don't even need any actus reus or mens rea. Yes or no? The fundamental concept of the criminal jurisdiction speaks about, or criminal laws, crime, where you have actus reus and mens rea. When you do an act with an intention, that is enough to constitute a crime. But here in this particular case, there is no crime. There is not even actus reus. There is not even mens rea. In the anticipation that a particular fellow may commit a crime, You are arresting an individual. You are curtailing the liberties. You are curtailing the liberties, the most precious articles. That is 19, 21, 14, 19(1)(a). So just imagine, had I done anything wrong, you can punish me by curtailing my rights. No person shall be deprived of his life or personal liberty except in accordance with the procedure established by law. Now that is the problem with the expression procedure established by law. In the countries like US, you have something called as due process. Due process of law, which says that while law is functioning, you should factor in the other elements and it should not be mechanical application of law. You should see whether the law is just or not. But procedure established by law, even if that procedure is unjust, since it has been established by law, you are supposed to follow it. That was the interpretation which was given. Why? Because he is detained. How? Under the preventive detention law. Does the law authorize a procedure for detaining him? Yes. Then it is good. That's it. Now don't you think that this kind of interpretation is going to cause much more problem in the future? Yes or no?
Yes.
Obviously it will cause much more problem to the persons. Today it is 1, tomorrow it will be 1,000. So procedure established by law. And then subsequently that was also diluted and they told that even if it is a procedure established by law, it should be just, fair, reasonable. Just, fair, reasonable. Law should be just, fair and reasonable. Then only it can be applied to the people. So now before we start with the journey, you know who are these gentlemen? I bet that no one knows. One or two, rarest of them. That Swamiji, you know. That Swamiji, you know. This picture shows all the gentlemen who lost their cases. Who lost their cases, but it was the democracy which won in their case. And glad to these people, thankful to these particular people. See, if nothing entered or nothing came before the judiciary, what would have happened? If judiciary was not there to act as something called as limitation, what would have happened? You know, unrestricted power, monkey in a banana field. It keeps on destroying, unrestricted, unbridled. Now here, it shows some gentlemen who went to the courts for some other reason to protect their rights, but they ended up becoming legends. They ended up becoming legends. Each one of them is a legend in his own right. And particularly these zamindars, with the exception of one or two in that particular thing, but the other zamindars will find that that is how the journey has started. It all started in the context of Article 368. The amending power of the Constitution. I told you, it does not have any kind of limitation. It only prescribes the procedure. It doesn't even define what is amending power or what is meant by amendment. It simply says, this is how you can change, this is how you can change. But where is the restriction? What can be treated as amending power or amendment? What does it include? Or to what extent it is permissible? All these have to be taken into consideration. So it led to the tension between the constituent power versus the sovereignty of the Constitution. You know what is constituent power? Law students, they know that there is a difference between the functioning of the parliament and the state legislatures. When it comes to state legislatures, as I told you, they can change the laws, which they can. That is known as the power of amendment. They can make the law. That is known as the power of legislation. Legislative power includes the power to change the law, any other ordinary law. But when it comes to changing the Constitution itself, that power is not vested with any state government or state legislature. It is vested only with the Parliament of India. Now when we speak about the Parliament of India, the power to change the constitution is known as the constituent power. Constituent power. Why? Because the Parliament of India is the successor body. Successor body to whom? Constituent Assembly. You should remember that the Constituent Assembly of India functioned as the interim parliament till the elections were held in the year 1951. Till that particular time, it functioned, it doubled up as both the parliament as well as the Constituent Assembly. Now, these powers have been transferred to a successor authority, that is the Parliament of India. The constituent power is there, power to make the constitution. But at the same time, on one hand, you are saying that the constitution is supreme. Why it is supreme? Yes, it is the law of the land. Law made by whom? People. It is the people. It is the people under something called a social contract. Those who have studied social contract theory, they know that people came together, stated that these are the authorities, we surrendered our rights in favor of those authorities, and that particular authorities are under obligation to protect our life and liberty. And when such kind of delegation has been done by the people at large, you will find that Parliament, Constitution is supreme document. It is not like any other law. It was not even made by the Parliament itself. Yes, Parliament did not make the Constitution. It was in fact Constitution which made the Parliament. So in that particular context, there was some sort of clash when it comes to the constituent power versus sovereignty of the Parliament. Now the question here is there any limit to the power of the Parliament to amend? Where lies the limit? Or where is the limit? That is the question. So that has prompted the judiciary to start exploring the amending power of the Constitution, giving the detailed exposition pertaining to the amending power of the Constitution. It all started in the year 1951. Once again, after A.K. Gopalan's case, which said that procedure established by law. If the law says, it had to be done. So no fundamental right can override the law. That was the norm back in those days. So in Shankari Prasad's case, what has happened is very simple. To ensure equality of income, basing upon the socialist ideology, the government went, or the parliament went to the extent of bringing a constitutional amendment giving effect to the Zamindari Abolition Acts. The issue of Zamindari was rampant throughout the country. System was there, but the Zamindars were known by different names. In some areas they called them as Zamindars. In states like Hyderabad it was known as Jagirdar. System is same. So what has happened is Zamindari abolition was necessary to ensure that excess land is taken away and redistributed to the landless poor person. So Zamindari abolition enactment was made. So Shankari Prasad, one Zamindar, got aggrieved. And these Zamindars were notorious for challenging almost the first 25 amendments. Why? Because there was one inherent flaw in the constitution. That flaw existed in the form of none other than a fundamental right itself. That is 19(1)(f). Most controversial one. That is right to property. It stated that no person can be deprived of his property except in accordance with the law. Now what has happened when this kind of enactments were enacted, abolishing of Zamindari and all, they are essentially depriving the persons of their property rights, right? And remember, Zamindars were no ordinary present day landlords. They used to hold thousands of acres, hundreds of villages under their control. Now, obviously when they are losing their property, see, if I have only one second-hand scooter, that is also a property. If I have 10 or 20 Rolls Royce, that is also property. For me, that is the only property. For that fellow, it is the only property which they have. So there is no limit as to what can be the property. or the quantum of power. So here these zamindars went, and especially Shankari Prasad, he went and he challenged that particular amendment and also the constitutional validity of these kind of zamindari abolition acts. So it was held by 3 judges bench that law in Article 13, you know what is Article 13? It defines the law and it empowers the judiciary to use the power of judicial review. It says that any law which touches upon the fundamental rights needs to be struck down. You have doctrine of eclipse, doctrine of severability. You remove that inconsistent part, and rest part, if it is surviving on its own, apply it. So when such kind of numerous interpretations are there in law, they said that law in Article 13 does not include constitutional amendment. So law under Article 13 means any other ordinary law, but not the constitutional amendment. Constitutional amendment is altogether a special provision. We consider it as a special provision. And since Article 368 only speaks about the procedure for amendment, it does not speak about the limitations. It is deemed that the power under Article 368 is absolute and unfettered. Absolute and unfettered, unregulated. What they said is, you see Article 13. Does Article 13 speak about constitution amendment? Plain reading. All those who are in the legal field, they know. The literal interpretation. Yes, the literal rule of interpretation, what it says. You use the language as it is. Don't go behind that. So what has happened is, law under Article 13, they have seen whether there is any particular word called as constitution or constitutional amendment. No. So it is not referring to 368. Now come back to 368. Does it impose any kind of limit? It only says 3 procedures. So since 3 procedures are there, and the law under Article 13 is not speaking anything or referring anything about the constitutional amendment, so 368 is not covered or will not come under the regulation of 13. It is independent. Now what is the extent? Since the constitution itself is silent, it is unfettered. You can do whatever you want. It is unfettered, unregulated, absolute. You can do whatever you want. Yes or no? If there are any limits, it would have been prescribed by none other than the constitution makers. When they themselves were silent, then there is no point in we adding to something. Why? Because in certain kind of cases you will find that judiciary also maintains restraint. Judiciary also maintains something called as judicial restraint. Policy decisions and all, the court, you might have heard court saying that it is a policy matter, we don't want to interfere. Why? Because it leads to something called as judge-made law, which is looked down upon in the legal circles. It is the job of the parliament, not job of the judiciary. The job of the judiciary is to interpret. And sometimes what happens when the law itself is silent and the situation demands that someone should take action. In such kind of situations, we will find that the judiciary steps into the picture and it will make some sort of guidelines till the parliament comes up with a proper law. One such good example is Vishaka guidelines. Workplace harassment, prevention of sexual harassment at workplace for women. So earlier it was not there, but still they went on, they made the guidelines empowered by something called as Article 142, that is power to do complete justice, to ensure that this gap, till the law is made, these kind of guidelines ensure that there is no sexual harassment at workplace. Now what has happened is, in this particular case what they have told, judiciary itself applied the simple meaning and told that the power under Article 368 is absolute and unfettered. It is absolute and unfettered. You cannot control them. Then, constitutional amendment is not covered under Article 13. So, technically, constitutional amendments can go to the extent of even attacking the fundamental rights. That is what the interpretation which came up in the case of Shankari Prasad in 51 by 3 judges bench. But this doctrine seems some sort of problematic. Why? Because unrestricted power, if a particular political party is enjoying absolute majority in the parliament, they can do anything. Technically, they can do anything. And such kind of experiment was done. 42nd Constitutional Amendment, which is also known as the mini constitution. Yes, did you ever go through the gist of article, this thing, 42nd Amendment? It fundamentally changed everything. Parliament 6-year term, the elections cannot be challenged. Judiciary is highly limited. So it became some sort of problematic in nature. If this kind of interpretation is there, that is the obvious knee-jerk reaction of the parliament. Immediately what they will do, they'll use their entire authority, special majority, and they will go to the extent of destroying the rights of even the innocent individuals. So that led to the another case. That is the case of Sajjan Singh. Here also, Sajjan Singh is an aggrieved party. He was also a member belonging from royalty, from royal bloodline. So he challenged the 17th Constitutional Amendment, which abolished privy purses. You know what are privy purses? Privy purse was some sort of pension which was given to the Indian kings when they surrendered their states to the Indian Union. Accession, when they acceded to the Indian Union, that was one of the conditions. That they lost their entire properties and all. Now they don't have any kind of sovereignty. So as a concession, what should be given? Okay, we'll give you pension for maintenance and upkeep of their households, which were coincidentally very large, not small family consisting of nearly 20, 30 kids, 10 to 12 wives. So that was the situation back in those days. So privy purses and all, it became a huge financial burden. Not to mention that when the government is having socialist inclination and all, you cannot let a person enjoy a privilege which he did not earn. You cannot allow any king to enjoy the privilege. Did he do anything? No. Did he earn that position? No. Why? Because just because he was born into that royal family, he is enjoying that status. Is he controlling anything? No. Is he the sovereign? No. Then what is the necessity of even giving them pension? For their abolished properties, we have given compensation. Yes, Jagir abolition and all, you have seen that some sort of one-time compensation was given to them. But here in this particular case, no nothing. So abolition of privy purses were challenged before the Supreme Court, and this time it was a larger bench. 5-judge bench of the Supreme Court has stated that the Parliament has authority. They reiterated the position which was there in Shankari Prasad, stating that no, Parliament has got every power to amend the Constitution, including fundamental rights. Why? Because the same analogy they have applied. 13 does not speak about constitutional amendment. When it comes to the 368, there are no boundaries. So the combined result is Parliament can amend the Constitution beyond recognition. They can do whatever they want, even they can touch the chapter 3 of the Constitution. Now, this was for the first time in the case of Sajjan Singh that there were two dissenting voices. Even though the judgment was given by the majority of 5 judges bench, there were two dissenting voices by Justice Hidayatullah and Mudolkar, who spoke about, even though supporting the conclusion, they spoke about something called as inherent limitations, stating that okay, that is the acceptable position, but there should be some sort of inherent limitation. There is some sort of implied limitation, unspoken limitation, which Article 368 refers to. But since it is the majority opinion, that did not come into the picture. But still, two dissenting voices were there for the first time in the case of Sajjan Singh. Now this has gone to the next level. That is one interesting case which you already know, that is the case of Golaknath versus State of Punjab, 1967. Now we move on a little bit further. And one interesting fact, do you know who was Golaknath? He was not a zamindar. He did not even belong to any kind of royalty. But here, Golaknath was an evangelist. Golaknath was an evangelist, a preacher who preached Christianity. He came all the way from Bengal and he settled in Punjab. And now also you can see, at Jalandhar you have Golaknath Church, named after his memory. So here also the estate abolitions etc. happened. So here what they have done is, he again challenged the power of parliament to amend the constitution. Here it spoke about land ceiling. You know what happens in land ceiling? They say that you cannot hold more than this many extent of land. Any other extent will be taken away from you. But it amounts to the deprivation of property, which is already there under 19(1)(f). Again problem. So that prompted Golaknath to challenge it before the Supreme Court of India. And this time, a larger bench, that is 11-judge bench, went on to examine this particular limitations. What they held that is the fundamental rights cannot be abridged or taken away by the amending procedure in 368. This is for the first time they told. That amending process or the amendments under 368 could not go to the extent of abridging or taking away the fundamental rights. The first time they told that there is some sort of limitation. You can touch any other part of the constitution, but you cannot touch part 3. Why? Because law under Article 13 remotely refers to the constitutional amendment under 368. Earlier they told that it is not referring to the other, and then they come to the ground that 368 does not have any limit. Now they read both of these provisions together and came down to a conclusion that the power under 368 cannot be extended to the extent of destroying the fundamental rights. You cannot destroy them. You cannot destroy the fundamental rights. You can amend any parts of the constitution, but fundamental rights are something to be kept in the constitutional vault. Safekeeping. It cannot be touched. So any constitutional amendment which takes away the fundamental rights is void to that particular extent. And an amendment to the constitution is law within the meaning of Article 13. Earlier they told that it is not the part. Now they are saying that it is the part. Now they are telling that it is one of the part of the constitution. Constitutional amendment comes within the purview of law. And in the Golaknath's case, they came up with an interesting doctrine, that is doctrine of prospective overruling. They said that whatever we have done till now, constitutional amendments which have been made till now, violating the fundamental rights, we will not touch it. Why? Because touching something in a retrospective manner tends to dig up many problems. If you are applying it to the future generation, it is okay, but retrospective operation is a very problematic thing. So what they told, from today onwards, from tomorrow onwards, whatever the doctrine of prospective overruling is there, tomorrow itself, we are telling that any law which is touching upon the fundamentals will be declared automatically as null and void. Now this doctrine gained a good footing. But the thing is, fundamental rights, sometimes what happens, in the great functioning of the state, the rights of the individuals or fundamental rights of the individuals may pose a problem in the wider interest of the state. Do you know any such kind of provision or any law? You already know, the thing is, about the land acquisition. Now what happens in land acquisition? Yes, anyone? Not ceiling limits, land acquisition. They give the notice and they take your land. You protest. But will it work? No. Why? Because here there is a broader issue. Interest of the public versus interest of an individual. Some 100 families may be affected. Okay. But at the same time, if that road is constructed or if that hospital is constructed, how many will benefit? So, here the interest of the public is the greater good. Interest of the public is a major good. It is the ultimate. See, any law which is working for the public good at large, is the good law. You cannot satisfy each and every person. It is next to impossible. So where the greater good of the public lies, the government will take such kind of policies. So in that particular situation, what has happened? They went on, and it was in the actual case of our Swamiji, which you have recognized. See, I told you, all of them are not zamindars. Some of them are zamindars, some are from royalties, two of them are religious leaders, Golaknath and our Keshavananda Bharati. So he died very recently also, two years back. So what happened in Keshavananda Bharati's case is, again, Estate Abolition Act made by the state of Kerala was challenged. This Swamiji was holding large extents of land. Since he was the head of the religious order, he challenged it before the before the High Court, and from High Court it went on to the Supreme Court of India. Now it was the question. Now he told that this kind of acts are violating my fundamental right to property. Fundamental right to property. Let me tell you, fundamental right to property was nothing short of a virus left in the body. Nothing short of a virus. You cure it, after some time it will come back again. You make a law, try to dilute 19(1)(f), another challenge came. You make another law, again challenge. So as long as 19(1)(f) was there in the Indian Constitution, it became a huge mess. So Keshavananda Bharati, it's not 1967, it is 73 actually. So it is 1973, what has happened is, in this particular case, the constitutional validity of Kerala Land Reforms Act, which abolished the excess land holdings, was challenged. Now, here again the Supreme Court got an opportunity to examine the extent of the amending power of the Constitution under Article 368. What is the extent? To what extent they can go? Golaknath, in that particular case, they told that it cannot touch any fundamental rights. But let me tell you, can you restrict your interpretation only to the fundamental rights? Fundamental rights are important. Why? Because they are basic. But at the same time, do you mean to say that the other parts of the Constitution are insignificant? Or they don't have any kind of actual constitutional ethos? Can we say? No. Each and every part of the Constitution is important in its own right. Fundamental rights are considered to be more important. Why? Because it is directly connecting the citizens. The other provisions, they are indirectly speaking about the citizens. That's it. So here they got an opportunity to re-examine this particular issue. Whether it applies only to the fundamental rights, or should we widen the purview, or to cover some other things which are not covered under Part 3. So this time it was heard by 13 judge bench, the highest in Indian history. And in fact, at that particular point of time when Keshavananda Bharati's judgment was given in 73, the entire strength of Supreme Court was 13. So you can say full bench judgment of Supreme Court of India. Full bench. But in state high courts, full bench means only 3.
Full court.
Longest duration, 68 days of hearing. Beating the point to death. By both the sides. See, both the sides were ferocious enough in their arguments. 68 days. Back in those days, you don't have any kind of communication. But had it been the recording, live recording like today, you might have seen. And it was unfortunate that we don't have any kind of video recording of back in those days. It was argued by brightest legal minds in the country. From both the sides. It is not as if that the government was sitting there. Government was equally ferocious. They hired the topmost legal brains. And even these zamindars, Swamijis, etc., they also hired the topmost legal brains. And that is how it has happened. Unlike the present day arguments which you see. Present day arguments cannot be called as arguments. It is unfortunate that In some kind of courts, you have videos coming. Judge is scolding the advocate, advocate scolding the judge. Why? Because both of them are not maintaining any kind of restraint. Some judge, maybe due to his work, he will get irritated and he has stated something. It will not be welcomed by the bar. Then bar fights against the bench. And ultimately, you know what happens. Section 10. Section 10 of what? Contempt of courts. Now the things are going out of hand. But just remember how it would have been back in those days. Entire Supreme Court is sitting for 68 days doesn't mean whenever the matter is called. That might be the only matter where everyone was sitting. Continuous 68 days of hearing. From October till March it has happened. They have considered. See, whenever the constitutional debates are there, they will do the comparative analysis. And in the year 1973, our Indian constitution was not that old. It was very young. So they had the opportunity of considering the other constitutions also in their judgments. That is how the law develops. So it was in this particular high stake case, that is 13 judges bench, where with a very minor or what you can say, with a very narrow dissent, it was held that the power of the parliament does not extend to the level of amending the basic structure of Indian constitution. You know what was the majority? 7:6. Now then also, don't be fooled by the number 7:6. Within that judgment, that is the dream, ultimate dream of any law student is to read at least once in a lifetime the judgment of Keshavananda Bharati. Have you ever attempted at least? What has happened? You tell me the result. After 3 to 4 pages, we will go into some sort of constitutional euphoric state. You don't know what is happening. You are reading, and ultimately you will come to the point, where did we start? What are we dealing with? So any person remaining sane after going through that 600 pages of judgment is a divine miracle now. 600 pages with very narrow font, with very less space. Ippudante you have 1200 pages judgment, double spacing, 14 number font and all. Back in those days it was not like that. So within that 7:6, some concurring, some dissenting. You know what is concurring but dissent? Independent judgment. I say yes to you, but in my own reason. And I say no, but I will concur with your result. So that is how it has happened, and finally it was 7:6. That is what you are supposed to remember. 7 stated that the amending power do not extend to the extent of demolishing the constitution or touching even the basic structure. That is, for the first time, what was implicit in the Indian constitution was made explicit, was made openly declared by the basic structure doctrine. So what they have told is, the parliament has wide power. See, what they have told is, they have recognized the right of the parliament to amend any part of the constitution. Now, unlike this thing, Golaknath, which told that fundamental rights you cannot check, it is not the situation now. You can amend, you can touch each and every part of the constitution. That is within your power under 368. But remember, this power is not limited. Not unlimited, sorry, it is limited. It has to be limited. Why? Because we don't follow the system of parliamentary sovereignty. We follow the system of checks and balances. There should be some sort of check or balance over the authority. So what it has stated is, parliament cannot alter or destroy the basic structure or the basic features of the constitution. There is some sort of hidden features in the constitution which cannot be destroyed even under the power exercised under 368. Even under the power which is given under the 368, you cannot go to the extent of destroying its true essence. Now what has happened is, they clarified in clear terms that amendment means to change to modify, to improve without destroying. You add anything, you try to modify it without changing the original substance. Without changing the original substance. That is just like any kind of alteration made to your clothes. You can increase the size, reduce the size, make additional attachments, etc., but you cannot change the fabric. That is what they meant to say. And remember, 368 doesn't mean abrogation or destroying. 368 doesn't imply or does not even remotely speak about abrogation of the constitution or destruction of constitution. You know what is abrogation? Totally repealing it. It does not empower the Parliament of India to undertake this kind of things. You can change, you can do whatever you want. But the thing is, you are not supposed to touch the basic structure. That is the very fundamental doctrine which was laid down in the case of Keshavananda Bharati. Now, what constitutes the basic structure is nowhere given. But these kind of principles or the ideals which constitute or the components which constitute the basic structure can be taken out or culled out from the judgments given after the Keshavananda Bharati's case. In the Keshavananda Bharati itself, they spoke about, or in the different judgments given in that particular 7:6 verdict, you will find that they have spoken about something called supremacy of the constitution. We don't speak about the parliamentary sovereignty. We say that the constitution is above all, even above the President of India, even above the Parliament, even above the Supreme Court. So, supremacy of the constitution is one of the fundamental pillars of Indian constitution itself. If I am not supreme, there is no point in calling me as a constitution, right? The difference between any other law and constitution, what is that difference?
All laws are in the ambit of constitution.
All laws derive their power from the constitution. And constitution is the mother. It is the grandmother. It is from the constitution that all the other laws, legal rules in the country derive their source. Right from any kind of notification or circular orders also, derive their source right from the constitution itself. So, when such kind of structure is there in the society or governance, constitution is always the supreme one. Constitution is always the supreme. The second one is republican and democratic form of government. Republican, elected head of the state. Who is the head of the state in India?
President.
It is the president, not state government, it is state. That is the president. And it is a republican. Do you elect the president of India? The answer is yes, indirectly. Your public representatives will elect him. So indirectly you are electing him. Then at the same time, democratic form of government. What is democracy? Once in 5 years.
Elections.
Voting right, that is the attribute. But there is one flaw with the democracy. Democracy is the perverted form of governance by many, not stated by me, by Aristotle, thousands of years ago. Why? Because there is a problem with democracy. And rather people call it as mobocracy. Brute strength of numbers is enough in democracy. Whereas he referred to as something called as polity, which is the good form. Polity, intellectuals like you people, ruling the country. Don't know your hidden enough. So when it is being ruled by the intellectuals, then the results are totally different rather than mob. So nevertheless, we follow the democratic form of government for the people, by the people and of the people. That constitutes one of the basic structure. Then there is something called as one of the most controversial basic pillar, that is secularism. Now what people say about the secularism or what actually is secularism is totally different. So total separation of religion and all, initially it was not there in the constitution. You know why? You know that it was included through constitutional amendment, but initially there was no secularism, right? Right under the nose of Dr. B.R. Ambedkar, the word important as secularism was not included. You know why? If you go through the Constituent Assembly debates, and specifically if you speak about Dr. B.R. Ambedkar's speech, he wanted to avoid the word secularism. You know why? Not because he wanted to give domination to one particular religion, no. Why? Because secularism is absolutely a Western concept. It speaks about complete separation of religion from the government. But if such kind of separation is there, then when it comes to the social evils in India, especially caste system, ostracism of widows, prohibition on temple entry, all these practices you cannot touch if you use the expression secularism. That is what he said. No, it is not me, or it is not something which I read from any TV interview. No, it is there in the constitutional text. Go and read the Constituent Assembly debates, you will know. There are other members who told that no, don't use that word. Why? Because if you use that word, you will stop the proactive role of government in bringing the social reforms. Secularism, you cannot enter that area of religion. But can you afford to have such kind of religious evils, child marriage, etc. being practiced again and again? No. You want the government to play the role. So therefore you avoid that word. Why? Because secularism is absolutely a Western concept which cannot be fitted into the Indian context. Or for that matter, Eastern societies, Eastern world societies, where religion is part of their culture. Religion is their day-to-day life. So secularism was treated as one of the parts, and in the case of S.R. Bommai also it was upheld that secularism is one of the basic structures of the Indian Constitution. Then you have separation of power. Obviously, each domain has its own power and authority. Separation of powers and checks and balances run hand in hand with each other. If separation of powers are there to the strict extent, or you can say watertight compartmentalization of powers, that is what the expression they use in administrative law. If you do that, you know what will happen? The India will have 3 heads. You cannot afford to have 3 independent heads. So to control, one head will control the other 2. So that is the system of checks and balances. Separation of powers, if you know Montesquieu, the doctrine of Montesquieu from the French Republic. Federal character. They say that Indian Constitution is unitary with federal with unitary bias, or federal with strong centralizing tendency. Even though our federation works in a different manner, it is essentially a federation. You have the broad separation between states and the union. And we follow something called as the union model. You know the difference between union model and federation model. Federation model, each constituent units are independent. They have the power to come out of that particular group, federation. Seed. Yes, just like your US,
Yes.
where you can come out of that particular union. But in India, it is only one-way route. Indestructible union of destructible units. That is what we use. It is a union. Union is stronger than federation. Federation without any option of exit. That is what your union is. So federal character of the constitution, distribution of powers between 2 units. That is one of the things. Then judicial review. You know what is judicial review? The entire journey which we are dealing with is the result of judicial review. Judicial activism. Wherever the law making goes to the extent of violating the rights of the people, it can be challenged. It can be challenged. That judicial review is one of the essential characters. It is the power of the court. Constitutional courts especially, that is the High Courts and the Supreme Court, to strike down any law or to examine the constitutional bias or the authority, whether they are overstepping their boundary or not. Judicial review. Where can you see judicial review?
Right, but
The entire writ jurisdiction is about the judicial review. Then you have freedom and dignity of the individual. Freedom and dignity of the individual, that is what you have, is one of the basic structures. In the preamble itself it says dignity of the individual. You cannot degrade So all these things have translated into some or other laws in our day-to-day functioning of the state. Then you have consolidation and expansion. The things which are said in the Keshavananda Bharati are firm. Now what they have done is, now through subsequent judicial pronouncements, they have added more and more features. More and more features, it has become add-on version now. So here what happened in the landmark case? You know what is this case? Indira Nehru Gandhi versus Rajanarayan. Here also another Zamindar, not Indira Gandhi, Rajanarayan was the Zamindar. What happened, you know? Famous expression, firing the Prime Minister for a parking ticket. That was the Western interpretation. The election of the Prime Minister, erstwhile Prime Minister of India, was declared as null and void. And later on, what happened with Rajanarayan also, you know. He joined that party. That you don't know. You only know that he has challenged to that extent. Now in that particular case, what she has done, since the election of the Prime Minister was called into question, they wanted to provide some sort of immunity to the elections of the office of the Prime Minister. So along with Prime Minister, what they have done, office of the Speaker also they have joined. Because if I bring Prime Minister, people may think that I am safeguarding my office. So also include the Speaker. So what they have done, they brought 39th constitutional amendment which stated that elections held to the office of the Prime Minister and the Speaker of the Lok Sabha cannot be challenged before any court of law. Now in a democratic system, can you have, the people themselves are giving power to you people, can you act in an autocratic manner? That was the question. So what happened is, in that particular case, they told that free and fair elections and judicial review, both are the basic structures of the Indian Constitution. And the amendment was struck down. Why? Because it is violating these two principles. Free and fair elections. And also the judicial review. You are taking away the power of judicial review. At the same time, you are not ensuring that there are free and fair elections in the country. So both of them are deadly. So this kind of amendment which tries to bring down those kind of essential features cannot be given open hand. So the amendment was struck down. So again, in the famous case of Minerva Mills, you might have heard about Minerva Mills in your constitutional law and all, but actually what they have done is 42nd constitutional amendment, controversial one. I told you, 42nd constitutional amendment tried to fundamentally change the entire constitution itself. So as a part of that particular change, they wanted to give primacy, that is elite treatment to the directive principles of state policy over the fundamental rights. You know, there are certain directive principles of state policy which tend to violate the fundamental rights. I tell you one good example. Prohibition on liquor. That is there under directive principles of state policy. No. But at the same time, 19(1)(g). What is 19(1)(g)? Carry on any kind of trade, profession, occupation. Now, don't you think that both are contradictory? Now, in the ordinary course of nature, what they will say, fundamental rights shall prevail over the directive principles. Why? Because they are not enforceable. So there is no question. But see the broad picture. It is speaking about a good public policy. Directive principles are speaking about good public policy. To avoid the youth getting spoiled, to avoid the homes being destroyed. Something which is deadly to the health should not be permitted. So, in some kind or in many cases you will find that there is an inherent clash. So to avoid that particular clash and there is one particular directive principle of state policy which they wanted to give supremacy. You know what is that? A directive principle under 39B and 39C. Prevention of concentration of economic wealth and redistribution of resources. You allow any great private enterprise to work. It is causing concentration of economic wealth. Wealth will be in the hands of very few people. And redistribution. Some people, you in the society, in the economic lens, you know that some people are known as haves and some people are known as have-nots. That is always there in the society. So when everything is concentrated with the haves, your job is to redistribute them to the have-nots. So they came up with this kind of, one kind of, not 42nd Amendment, this particular area where primacy was given to the directive principles over the fundamental rights. So what they told is, limited amending power of the parliament itself is a basic feature. The limited power of amendment itself is a basic feature, which you cannot touch. Why? Because if I touch the limited amending power, then what I am ensuring? I am ensuring parliamentary sovereignty, which was never intended in our Indian constitution. Then comes the balance between fundamental rights and directive principles. Both of them are beneficial for the country. So you have to take a particular course of action which covers these. You have to take a particular course of action which will balance both of them. There is something called as doctrine of harmonious construction. You know what is that? Doctrine of harmonious construction. When two contradictory provisions are there, you try to interpret them in such a manner that you render both of them effective. You call it as a middle path, right? Both of two contradictory provisions are there. You take a middle path so that no damage happens on the either side. Or even if it happens, only minimal damage is there. So what they have told is, balance the fundamental rights and directive principles. Both are important for the nation. Fundamental rights for the individuals. Directive principles for the entire group at large, public at large. So, after this particular case, there was another Zamindar, Vaman Rao. Vaman Rao versus Union of India, 1981. So, those who are into the land litigation or this thing, they know that basic structure doctrine pertains to them. The first 25 amendments concentrated mostly on the property rights itself. And this nuisance came to an end. You know when? 44th Constitutional Amendment, 1978. You know what they have done? They removed this 1901. They removed this virus. Why? Because much of the constitutional developments till that particular year happened to that particular extent. Went on to that particular extent. So now what has happened is, in Vaman Rao, now comes something called as constitutional vault and cut-off date. Now what they have done is, the judgment as given by the Supreme Court of India in Keshavananda Bharati on 24th April 1973 was taken as a cut-off date. And they told that any laws in the 9th schedule, any laws, you know, due to the constitutional amendments, due to the frequent challenge from 1901F, they created or they introduced the 9th schedule to the Indian Constitution, which is also known as constitutional vault. You know what is a vault? Safekeeping. Anything which is there in the vault cannot be touched that easily. So what they used to do, all the laws which are controversial or which tend to hurt the 1901F was placed under 9th schedule, and there was this amendment which said that any law placed under the 9th schedule is immune from judicial review. Now, then again, it is taking away the basic structure, that is judicial review. So what they have done is, under this 24th April 1973 Keshavananda Bharati statement, they told that any law which is placed under 9th schedule after this particular date can be challenged on the ground that it violates the basic structure. Now the question is, what will you do about the things which have been done prior to 1973? The law might have been notified prior to 1973 under the 9th schedule. But the problem is arising now. Can you say that since it was before Keshavananda Bharati, you cannot touch? Now, that kind of restrictive interpretation will do no justice to this doctrine. So finally, this was given the final shape in the case of I.R. Coelho versus State of Tamil Nadu, 2007. In IR what they have done is 9 judge bench, again a larger bench. Even if a law is put under the 9th schedule, it is not immune from judicial review. Any law that damages or destroys basic structure can be struck down. So forget about 24th April 1973. Anything before or after, it is challenged. It is open to challenge, provided it violates the basic structure. So now whatever amendments they may bring, it is subject to judicial review, and it is subject to judicial review. And even if it is subject to judicial review, don't think that automatically it will be struck down. Why? Because that is a law which has been made by democratically elected legislatures. So, as a lawyer, if you go before the court and start challenging the validity of any act, you will be under the burden of proof, not the state. Why? Because state is authorized to do so, it has done. First you prove how it is violated. So now the position pertaining to the basic structure doctrine is settled to a great extent. Settled to the great extent. In future there may be certain things which may be added. Same thing happened with the National Judicial Appointments Commission and the constitutional amendment. It was struck down stating that it is violative of independence of judiciary. 99th Amendment, which was one of the basic structure constituting the basic structure of this thing. Now this particular doctrine is not free from any kind of criticism. The first and foremost criticism is it lacks any kind of textual basis. You might have seen while studying the law that important words are never defined in the enactment. Yes? What is a company? Company means company notified under this act. What is company there? Company notified. Company ante enti? That meaning is not defined. Or sometimes very odd things can be seen. See, Hindu Marriage Act you might have seen. Who is a Hindu?
Who is other than Muslim, Christian?
Who is not a Muslim, who is not a Christian, and then other persons who do not conform to any religion also comes within the meaning of it. See, they don't define. They leave certain things deliberately open for the interpretation. Why? Because while making the law, you cannot come down and make any kind of concrete definitions. So here also basic structure doctrine, what they say, basic structure or something such as basic structure, important as basic structure, was never thought of by the constitution makers. Who are to invent such kind of thing? Come up with some kind of innovation which was never thought by the constitution makers. It lacks any kind of basic this thing. The constitution, when it does not even define the amendment, forget about basic structure. So it lacks any kind of textual basis. Even for that matter, Article 368 even today does not have any kind of limitation. It's still open. It is still open. Then judicial overreach or counter majoritarian difficulty. Judicial overreach, they say your job is to interpret the law. Procedure established by law. But don't you think the judiciary is overstepping, overdoing its job of interpreting certain things? And remember, this comes in the light of a situation where you have judges who are selected in a very controversial process, or the process which is not open to the public at large, and versus the rights of the lawmakers who are directly elected by the people. That is where the present day controversy is revolving. They make a law which is struck down, immediately the parliament or the legislature, they will say judiciary has always made a point to strike down our laws. Why? Because they need not face any kind of criticism. But we, after 5 years, we should stand in the public again. We are elected by majority, but when it comes to judiciary, no. When it comes to judiciary, it is no. So that is, opens the door for tussle between both of them. They say, we are authorized to make the law. Why you are stepping into our boundary? And at the same time, judiciary says that I am the watchdog. I should act whenever the constitution is being defaced or destroyed. So this is where the controversy starts. And it is still at large, you might have seen. Then uncertainty and subjectivity. Now what amounts to basic structure all comes from the brain of a person authoring that judgment. It is completely subjective. See, had it been mentioned in the constitution itself, it would be objective. That is, you are just taking it away, lifting it away and putting it in your judgment. But here, you have understood it and you thought that it was a basic structure, therefore you have included it in the judgment. That is one of the criticism. They say that the judges should be objective while rendering the judgment, but sometimes where there are gaps, where there are certain grey areas in the law, invariably the judiciary is supposed to use their innovation. You are supposed to use their innovation, and during that particular innovative process, can you go into the subjectivity according to the feeling of the person? No. Then when it comes to the defenses, nevertheless, there are particular things in favor of the basic structure doctrine, which says that it works as a guardrail against constitutional destruction. It stops, a guardrail you might have seen in the hard roads and all. Even though it may not help in actually holding the vehicle, but it will give a psychological this thing that everything is protected. You will not fall down or you will not exceed your limit, go beyond. As a road divider, you can also say, preventing the parliament from using their unbridled or unfettered authority. Then inner logic of written constitution. A document meant to be supreme and enduring must have core identity. See, whatever document may be, let it be a small book written by you, that will have some sort of core idea, ideology. As said by one of our friends, that there are some kinds of ideologies behind some kind of books and all. Here also there is some kind of ideology. And that kind of ideology you will not get to learn if you read the first page. You have to go through the entire book, then only you will know what is its essence. Each document, meaningful document, has some sort of essence. And that essence is nothing but the basic structure. Then it says that protection of minorities and fundamental values. Here we are not speaking about religious minorities, but those who are not in power. Those who are against the majority in strength. So if such kind of things are not there, then there are every chances that the majoritarian government is going to trample the rights of the commons. Trample the rights of the commons. Or, I told you, if you have any kind of brute majority, virtually you can change everything. But if such kind of doctrine is there, it is not possible. So, that is with regard to the entire basic structure doctrine which is inherent in the constitution. See, you will not learn the beauty of the constitution until and unless you go into the depths of it. And to go into the depth of the constitution, you have to go through any kind of intellectually written works. For law students, it may be some articles in the magazine, etc. By learning about the constitution, one thing is you should have open mind. And please don't be guided by some of the TV debates are good, but some are majority of them are bad. You bring some 2 or 3 politicians cannot speak about the constitution. Let me tell you. Politicians are disqualified from speaking about the constitution. Then who? Statesmen. There is a difference between politician and statesman. Politician always says yes to no and no to yes. They'll always have to. But statesman, maybe, might be, somewhere in between. Why? Because he will see both the pros and cons of any particular thing. And it is the intellectuals, like you people, the lawyers, future lawmakers. You don't know which MP is sitting here, which MLA is sitting here. Oh, that was a general glance. So you don't know. You can become a lawmaker. Who better is qualified to be a lawmaker than an advocate? Lawmakers, if they are from the legal background, they turn out to be a very good intellectual, making the law and all. See, don't think that your voice doesn't matter. The voices of two judges giving the dissent back in those days did not matter back then. But now it has become the norm. Yes, Hidayatullah and Mudolkar, what they have stated, that was only a dissenting voice. There was brute majority which went away, and later on in Keshavananda Bharti everything changed. So that is how the innovation will come from you people. So basic structure doctrine is evolving doctrine, and in fact it is the evidence of the very breathing nature of our Indian Constitution. So with these few lines as said by none other than our Dr. B.R. Ambedkar, I will end my lecture. He said that if I find the Constitution being misused, I shall be the first to burn it. Why? It is not because he is vexed with the Constitution. He says that when the law is not dynamic, and in that particular dynamism, if it destroys the very content of that, very essence of that particular Constitution, then there is no point in having such kind of Constitution. You know, it is not the length or bulk of the Constitution which determines. Some of the greatest constitutions are weakest in implementation. And some of the weakest constitutions are strongest in implementation. You see the US Constitution, you call it strongest. Why? Because the implementation is very fine. But do you mean to say that it is free from any flaw? No. You know, there is one greatest flaw in US Constitution. It gives fundamental right to carry arms. Now what is the result? Now they wanted to change. Is it that easy? Arms and ammunitions in US are very easy to get. For girls, they have pink colored fairy tale princess themed guns. Yes, there are showrooms like any other electronic gadget showrooms. But luckily in our country we don't have such kind of things. But why? Because ours is a dynamic constitution. We want to change such kind of things. But US, they are feeling the problem now. Why? Because bringing the amendment is not that easy. For them, all the states should say yes, which will never happen. Which will never happen. Capitalistic economy, their social conditions are different. So remember, it doesn't depend upon what kind of constitution it is. It is always the implementation which matters. Always the implementation which matters. So there are countries like North Korea where they have a constitution. You have our good old neighbor Pakistan who have a constitution. And you know the beauty of that particular constitution, I don't know who made that one. It is copy-paste job of 1935, Government of India Act. When their entire country is copied from us, then there is no question of this thing. Now Government of India Act, they have copied, they made a constitution. And you know what it says? Wherever there is a constitutional crisis, the military general can take over the country. You have one particular word, I don't know what kind of funny republic is that one. You don't call it as republic also. Banana republic. Every country has an army, and in Pakistan, army has a country. That is totally different thing. If you look at their constitution, it is identical to the Government of India Act 1930 with some kind of changes. But when it comes to the implementation, God only knows. Yes?
Latest announcement, Asif Munir given field marshal rank with all the immunity. I am talking about
See,
Pakistan.
the biggest wonder about their generals is they have so many medals when they have won not even a single war. ఇప్పుడు నేను ఎగ్జామ్లో టాప్ అయితే I would get a medal. I failed in each and every exam in which I sat, and still I am having a medal and calling myself a gold medalist. So many gold medals for whom? For running the country. See, the plight of the people in such kind of country. Plight of the people in such kind of country. How it happens? Not that they don't have constitution, they have constitution, but the implementation is worst. In India, we often curse our urban areas for low turnout in voting. It will be 40, 35. Hyderabad ante perigadu. ఒక్కసారన్నా లైఫ్ 50% చూడాలని I don't know if it will happen. But in Pakistan, you know what will be the voting percentage for their parliament? 10, 8. They don't vote. And you know their taxing policy. The entire country will pay a single unified tax. So such kind of republics are there. Compared to, you can't even compare such kind of republics with our Indian constitution. So our Indian constitution is the growing one, it is the evolving one. And it will continue to do so as long as we have intellectuals as these people whom we have gathered today. So with this particular line, I will end my lecture and I once again thank the organizers for organizing such a wonderful event. Thank you.
Friends, first there is announcement. Uh, One vehicle is causing some disturbance there, obstructing to the regular market. Clarification or clarify certain doubts. I request our the president will conduct the proceedings. Somebody having some doubts, probably they can pose if it is a very short. Otherwise, please put it on paper. That's my request. You ask from there directly if it is a precise. Otherwise, put it on paper. Please.
Kindly settle down, please. We will conclude in a very short while. Now you have gone through the lecture of the sir. I think sir deserve a standing ovation. So please stand up and give a grand round of applause to sir. Thank you. I request K. Parthasarthi sir to come on the dais to continue.
Doubt session is over. You find out. Doubt session.
Students, if anyone is having doubt in a precise, you can ask right now, or if you are having a detailed doubt, then you can write on the paper and give to sir. Sir will get back to you. Sir.
So detailed discussion, there is no room for the doubt. Really, it's wonderful.
Hi, certificates.
Any more doubts?
When it comes to the preventive detention laws, we no longer follow the situation which happened in AK Gopal. There is a huge procedure now. So you have a particular board that is which speaks about the preventive detention at the state level. Once in a while they will meet and they will see whether they are going to detain any particular authority or to detain that particular person. Are there any kinds of reasons to extend that detention at all? So preventive detention has been diluted to the greater extent. But when it comes to the persons with history sheets, that is when it comes to the persons having criminal antecedents and all, still it is treated in a good manner, in a strict manner. So if you don't know, if you go to the police stations and all, you know you have some kind of 4 points board. If he is accused in one step, 4 points, one murder, 10 points, one rape, 6 points, like that it will be there. Once you reach that cutoff mark, congratulations, you have earned a spot in that detention list. And once your name is there in the detention list, no doubt wherever there is a law and order problem or any kind of social problem and all, first you will be detained. So that kind of system they follow. But it is not that easy as they used to do earlier. Now the judiciary is away, now various purpose provisions are there. So it is not that easy.
Any more? And I request Advocate Venkatesh sir, Telangana State Committee member, to come on the dais, please. We'll continue with the doubts.
Announce it.
Firstly, congratulations, very well conducted lecture, but I had one doubt. I thought the schedule live was played a bigger role right in the beginning itself in the land reforms were there. Why it was not so highlighted?
Sir, initially it was brought to protect the land reform legislation. Initially it was brought to protect the land reform legislations, but since they have found that what can be done under the ninth schedule, they start even remotely related to the land. Industrial disputes, election related laws, abolition of private estates, whatnot. They have nearly 289 laws which are placed under that particular. It was used as a shield. Now it is not. Now after the judgment in AILU, there is no room for doubt. They can be challenged.
There are two announcements. Those who are interested to buy AILU membership, they can buy from the reception. They can take from the reception. For students, it is 10 rupees for year, and for advocates, it is 25 rupees for year. So membership will be valid for 1 year. You can buy or you can take it. And another announcement: this book, Rajyangam Manake Michindi. Manake A Michindi. I am not good in Telugu. This is written by Justice H.N. Nagamohan Das. The MRP is Karnataka High Court Judge. The MRP is 90 rupees. It is available for 50 rupees at reception. If you are interested, you can buy. It is based on the Constitution. And now it's time to felicitate our key lecture today by the key member of our All India Lawyers Union Student Wing, LSFI, Anil Kumar. He is sitting between us.
Claps them.
Felicitation will be needed for 1 minute.
So there is one question: is there any nepotism in recruiting the judges? Because we heard now and then, even if you see in CJI of India, most of them having their parents in the same field. Now, when it comes to the legal profession, there is one thing you can't avoid is generational lawyers. There may be coincidence and there may not be any coincidence, but you know how the things are unfolding in the present day context.
Okay.
Just because a person has a parent in the High Court doesn't mean that you cannot attribute nepotism directly. But there are certain allegations. See, making allegations is easy. People go to the extent of making the allegation, but the thing is, when it comes to the proving that allegation, no one comes forward. That is the problem.
Sir, quickly. Ali Haider sir. Mike.
Nowhere in the Constitution it is mentioned about reservation to BCs, SC and ST. Majority of the people are affected, where majority of the people are affected, can't we remove the reservation? See, state cannot discriminate any person on the basis of gender, race, religion, caste, creed, sex, place of birth, etc. But the same articles speak about protective discrimination, positive discrimination, protective discrimination, like say educationally and socially backward classes. They use the special expression educationally and socially backward classes. They don't actually say backward classes, educationally and socially. So all the SC, ST and BC communities fall within that particular category. In fact, that is one of the criteria. Now when the majority is getting affected and all, see, they say that reservations are not good, it is merit. That is one sort of argument which I don't want to get into. But the thing is, even in reserved categories, if you see the open category cutoff and the reserved category cutoff, it will be somewhere close. It will be somewhere close these days. So, this kind of system cannot go on forever. Dr. Ambedkar himself has stated that for certain years. But rather than ensuring the protective discrimination and developing their lives, governments are more concentrated on populist measures. That is the problem. That becomes one of the criteria. But in future, God only knows when it ends. But it will end at a very high cost. That is the party which is ruling and which is ending this particular thing will be committing political suicide. That you.
Last thought. Two questions.
Last.
Ramchandra Reddy, let me tell one word about myself. One word. Sir, I am happy to see you back on the podium. I have been your student in Pendacantry. That's why I wanted to acknowledge him. Thanks. My question is there to provoke.
Judicial activism in a land encroachment, how to let us view when a long settled dispute since 1931 is encroached into the matter. The problem with land encroachment cases is we see that there may be one party who has committed mischief somewhere at some point of time. But the rest of the people who banged on that particular mischief, who believed, who are bona fide purchasers in that particular case, the thing is, law says that you should be vigilant, not dormant. But you cannot expect each and every person to have that kind of vigilance while entering into land details and all. So usually the person who has committed that kind of mischief long ago goes scot-free. But those persons who are genuine buyers, genuine purchasers, in present day context, they are going to suffer. Why? Because two wrongs cannot make one right, right? So that is what, when it comes to this thing, sometimes we feel that the judgments given by the courts are very painful. But the thing is, in the broad context of the people and people's life, it has to be protected.
Sir, recent judgment by Supreme Court says that unknowingly he has bought and he should be suffering because it is his onus lies on him to check the antecedent.
Yes.
But this is a long settled property since 1931, encroached in 2016. So, burden of proof or burden of entitlement or possession lies on the new buyer. Okay, he has bought and built the house. So, what is the recourse? Can the houses be frozen?
Whenever the title of any particular property is clouded, the subsequent, all the titles are always clouded.
True.
No matter you have invested crores of rupees or you have constructed houses, etc. Once around, always around.
Yes.
That
So
is the hard
house
interpretation.
constructed can be frozen and status quo antique can be given?
Yes, it can be given and they can even authorize the persons to even destroy that particular house.
It's not just take over.
Take over, that's it. When courts will end Western borrowed customs of saying my lord and prayer, then will English not be official language in courts and regional language? Now they are coming. Now they are coming up with the different using of Indian languages in the courts and all. That is a very good initiative. But the problem is when single English word is capable of so many interpretations, just imagine what the same word in different languages will convey. That is the problem. So English is used as a joining medium. So you don't think that English will be phased out. English will be there. But added advantage for the common litigants and all, judgments are being translated in vernacular languages, which is a good initiative. Even common man gets to know about that particular.
Now you can write and keep the dots because of the shortage of time. Now it's time to felicitate our keynote speaker today. Anip, welcome on the dais.
వస్తుందా?
Now certificate distribution will be there. We have choose few students from almost every college. Sir will distribute, give the certificate with his hand. Now I hand over mic to the Chandrakant, co-convener, to announce the names.
R. Rajkumar, A. Harshini, T. Rajeshwari, Vaishnappa, Chagam Vijayalakshmi, Korra Sharat, M. Taruni Reddy, P. Nagalakshmi, Ravinder Rathod, Himabindu, Ramyasri, Rajeshwari, Harshini, Rajkumar,
All other students kindly collect your certificates from the reception. All certificates are ready. Just say your name and take the certificate. Thanks for attending the session, and I now request Advocate Venkatesh sir, AILU Telangana State Committee member, to propose vote of thanks. Thank you once again.
Friends, being AILU Telangana State Committee, we have been regularly conducting the educative programs to the law students as well as the advocates. It is our regular activity. I request all of you to avail the opportunity because unless you educate yourself, unless you know the laws, the recent developments in the legal issues, you will become, unless you know all the laws and not get the knowledge updating yourself, you cannot become a successful legal practitioner in the legal field. So that I thank very much to the today's speaker, sir. You are imminent knowledge on the Constitution, gave a lot of knowledge to the participant of the today's program. I thank Vaishnav Kumar sir, having experienced your subject. We are all enriched with a lot of knowledge. We thank one and all who participated in this program. We wish you all to participate in the further programs to be conducted by the AILU Union. I thank one and all. This program is concluded.
I thank also the LSFI who is behind back of this conducting this program successfully, and being a lawyer, all India Lawyers Union, we are all thankful to the participants. Thank you very much.
వేరే వర్క్ ఉంటే వెళ్ళేదండి